guys, good day, peace and love to you. I'm going to be reading the Public Trustee Act, Chapter 199. It's only 22 pages. This is a 2011 version. Let me see, Public Trustee Act of Belize, updated. Let's see. I believe that's the most updated version. Well, yeah, it's the same thing. It's giving me the most updated version. Okay, so Public Trustee Act. So we're gonna go over this. These are the arrangements, right? Interpretation. We're gonna look at that. The appointment, powers, and duties of a public trustee. Okay, Office of Public Trustee. We're gonna get a better understanding of what that means. The registrar. To be public trustee till other appointment made. So the registrar is a public trustee. General powers and duties: appointment of executor, administration of estates, granting probate to public trustee, custodian trustee, appointment of public trustee, to be trustee, executor, etc. As guardian, committee, etc. Creditor may apply to public trustee to administer estate of absentee. That's interesting. Creditor may apply. Okay. Let's see here. Absentee to be communicated with if possible. Hold on. Excuse me. Proceedings on taking possession of estate and absent owner, liability of public trustee, a charge on consolidated revenue funds. Liability of public trustee, a charge on consolidated revenue funds. That's interesting. That's very interesting. Publication of list of monies unclaimed for 6 months. Monies received by public trustee to be paid into bank. Interesting. See, monies received. Look at this. Let me show you something. This is very interesting, right? This is money received. So we're gonna go. Let's come here and let's do a search. I'm gonna do a search for that's a General Sales Tax Act of Belize. Let me show you something. What is this? No, it's not that. General Sales Tax Act of Belize. Okay, right here. So I guess. The reason I'm bringing you here to this page is because I believe this is where they define money. You know, it's good to know what the definition is, right? Because this is their laws, right? So it says here, hey, money. Here you go. You see, money is right here. Money, any coin or paper currency, whether Belize currency, a negotiable instrument used or circulated or intended for the use of circulation as currency, whether of Belize or of another country. A bill of exchange, a promissory note, bank draft, postal or money order, similar instruments, whatever is supplied as payment by the way of a credit card, debit card, crediting or debiting an account, the creation of a debt or the transfer of a debt. Listen to that. The creation of a debt or a transfer of a debt. That's money. Whatever is supplied as payment, listen to it, it's right here. Whatever is supplied as payment by way of the creation, oh my goodness, of a debt or a transfer. You see that? Transfer. Right here. Transfer. Man, this thing sucks. Sorry about that. For that. So it's very interesting to see that, you know. And look, it says, and includes any amount expressed as any money, any amount of money, but does not include a collector's piece, investment article, an item. Anyway, so I'm just saying, right? We go back to, where is it? Public Trustee Act. Okay, monies received by public trustees to be paid into the bank. Interesting. So let's just start reading. Right, see, it's right here, part 1. Let me expand it, make it bigger. It says this act may be cited as a public trustee act. In this act, unless the context otherwise requires, court means the Supreme Court of any judge thereof, or any judge thereof. Okay, so a court means a Supreme Court, or it could mean a judge of a Supreme Court. Okay, estates includes every description of real and personal property, every description of goods, chattels, money, securities of money, and all writings relating to or evidencing any right or title to any property. Look at that. What type of title? What type of title? There's equitable and there's legal. Isn't that interesting? And all rights of action and claims. Actions. You know what's another one? Like, you ever heard of choose an action? Let's watch. What's a choose an action? What is a choose an action? Look at what, right? Choose an action. Look at law dictionary. I'm going to go to the source. Choose an action. It says a right to personal things of which the owner has not the possession, but merely a right of action for their possession. It says that. So it's like a promissory note, right? The owner of a promissory note might have handed that over by assignment to somebody else, or just said, they're not in possession of it, but they have a right of action to the possession. So it says a right to receive or recover a debt, demand, or damages on a cause of actions. So just want to let you know, it says or for a tort connected with contract. Connected, that's weird. Contract, but which cannot be made available without recourse to action. Interesting. So I'm going to bring that up so we can. Man, my computer is so. There you go. So that's a state. Private executor or private administrator means an executor or an administrator other than a public trustee. Oh, okay. Private administrator, isn't that what we are of our persons, of our labor, of our energy, of our properties? So it says private guardian or committee or receiver means a guardian or committee or receiver other than a public trustee. Okay. Rules means rules made under this act. Okay. Rules, not the law. Rules made under this act. Trust includes every case where any person acts as executor, or acts as a guardian, or acts as a committee, or acts as an administrator, or acts as a receiver, or acts as a sequestrator, and every case where any person, listen to that, any person is appointed by the court or otherwise the provisions of any act to administer the property of another person for his benefit. Did you hear that? For his benefit. Okay, so trust, remember, right? You got equitable title and legal title to think about. So legal title, if it is transferred or assigned to another entity, let's say a public trustee, he is now a trustee, and you're the grantor who assigned it, and if you appoint your person, well, there you go. Your person as beneficiary, or your person's account as beneficiary. And let's proceed. Will includes a testamentary disposition. Codicil. What? Okay, let's look up this word. What is codicil. Let's look at what is codicil. I think that's what it's. Legal definition of codicil. There you go. Is it codicil? Yeah. It says a testamentary disposition subsequent to a will, and by which the will is altered, explained, added to, subtracted from, or confirmed by way of republication, but in no case totally revoked. Okay. Okay. Will includes that. Okay. And an appointment by will or by writing in the nature of a will in the exercise of power. The exercise of a power, which is a right. Appointments, powers and duties, etc. of public trustees. So what's appointment? How do we appoint them? How are they appointed? What are the powers? What are their duties, etc.? What's going on? Okay, office of public trustee. The Governor General may appoint a fit and proper person, public trustee, under this act. Okay. The public trustee shall be a body corporate with perpetual succession, and may sue and be sued in that name. What does that mean? The public trustee shall be a public. So you know what we can do? Let's just break it down a little bit. Let's do this. Let's see if we can get. Let's ask Chad if he can break this down a little bit. Can you break this down in simpler words and terms? Oh, I spelled that wrong. Okay. Sure. Here's a simple version. The public trustee is an official organization that will continue to exist forever. Oh shit. And it can take legal actions, meaning it can sue others, or be taken to court and sued under its name. Ah, isn't that interesting? Isn't that interesting? Okay, that makes sense. Okay. Unless, now it says here, the registrar to be public trustee. Okay, there you go. So we know that anybody that the Governor General appoints is a public trustee. And then it says here, unless and until the Governor General appoints some other person to be public trustee, the registrar shall be the public trustee. And any person lawfully discharging the duties of registrar shall have all the rights, powers, and liabilities, and may discharge any of the duties of the public trustee. You hear that? Let's plug it in. A lot of people are like, what does that mean? It's very simple. Let's ask. Thank you. How about this one? Boom. Welcome. Here's a simpler version. Unless the Governor General chooses someone else to be the public trustee, the registrar will take on the role of public trustee. Anyone who is legally doing the registrar's job will have the same rights, powers, and responsibilities as the public trustee and can do any of their duties. So everybody that the registrar delegates power and authority to, or delegates any roles, it says here, any job, any powers or responsibilities. Boom. Okay, so that's interesting. So almost everybody's a public trustee that's under the court, right? Okay, so general powers. Well, general powers and duties, subject to and in accordance with the provisions of this act and the rules, which are the rules of this act, public trustee may, if he thinks fit, acts as an executor or administrator in the administration of the estates of deceased persons. He can also act as a custodian trustee. He can also act as ordinary trustee. He can be appointed as judicial trustee. He can be appointed as okay. He can act as a guardian or a committee or a receiver of the property of any infant or other person under disability, as the case may be. He can take possession of and administer the estate of any person who is absent from Belize and who is not fully represented by an attorney in Belize and who has left debts unpaid. Okay. Subject to this act and to the rules, which is the rules of this act. The public trustee may act either alone or jointly with any person or body of persons in any capacity. Wait, what's going on here? What is going on here? Oh, damn it. No. There you go. Okay, let's see. The public trustee may act either alone or jointly with any person or body of persons in any capacity to which he may be appointed in pursuance of this act, and shall have all the same powers, duties, and liabilities, and be entitled to the same rights and immunities, and subject to the control and orders of the court as a private person acting in the same capacity. Isn't that interesting? Well, let's plug it in. Let's see, what does this the simpler version. How about that? Let's watch what that has to say. Thanks again. How about this one here? Oh, oops. There you go. There you go. As long as it follows the laws and rules, the public trustee can work either alone or with others in any role they're appointed to under the law. They will have the same powers, responsibilities, and protections as a private person doing the same job, and they must follow the court's control and orders. Interesting. So, isn't this interesting? So if the court has granted interest, that's interesting. Okay, anyway, let's continue. It says a public trustee may decline either absolutely or except on the prescribed conditions to accept any trust, but he shall not decline to accept the trust on the ground only of the small value of the trust property. Isn't that interesting? See right here? How about this? Public trustee can choose not to take on a trust, either completely or under certain conditions. However, they cannot refuse a trust just because the value of the trust property is small. Even if it's $5. Alright, interesting. The public trustee shall not accept any trust which involves the management or carrying of any business, except when acting under Section 14 of this Act, or except in the case in which he may be authorized to do so by the rules, or any trust under a deed of arrangement for a benefit of creditors. Isn't that interesting? Now, what's Section 14 about? Right? What is that section? We gotta look. We gotta take a look. Alright, here we go. This is the proceedings on taking possession of estate an absent owner. Ooh, this is when there is no owner. They just take it, and this is how they can do it. See that? This right here. We're gonna get to this. It's interesting to know. That's where it is. Let's see, where do we stop? I'm pretty sure it was like at 7. Somewhere before 7. Yeah. Here it is. Yeah. Wait, is it right here? Yeah, okay. Right here, 7. Any person who... Is it right here? Where was I reading? Wait a minute. Okay, anyway, let me just read this, man, whatever. Right here, there you go. I'm right here. The public trustee, by that name, or any other sufficient description, may be appointed executor of a will by the testator, in the same manner as if he were a private executor, and in the case he shall have the same powers as if he were a private executor. Okay, let's see what this means to us. This is interesting. So we can appoint, that's what's happening, is that we can, anybody can go and appoint a public trustee. You know, most people get an attorney, yeah, he becomes an appointed executor, you know, but you can hire, you know, it's like for example, the registrar or the judge or anybody else like that. So, okay, how about this? So the public trustee can be named as the executor of a will, either by that name or another clear description, just like a private person can be. If appointed, the public trustee will have the same powers as a private executor. Isn't that interesting? It seems that a private executor has different powers as a public trustee, and the public trustee gains those powers, you know, as if it was a private executor. Oh, interesting. Any person, I'm right here, see? Any person who, in the opinion of the public trustee, would be entitled to apply to the court for the appointment of an administrator of the estate of a deceased person may apply to the public trustee to administer the estate, and the public trustee shall administer the estate unless he sees good reason for refusing to do so. You know, I like this one because administration of estates, remember that's the definition of estates, right? Look, to administrate real property, goods, chattel, money, securities of money, and all writings relating to or evidencing any right or title to any property, and all rights of actions and claims. Look, when we send the Minister of Finance that birth certificate back, right? That's the legal title that holds a right to the estate of that all caps name, man. Anything and under that name, give that back to them. They're official public trustee. It says here, right? Look, let's plug it in, man. Is that what we just read just now? Let's see. And this how about okay, wait a minute. This one. Any person. It says anyone who, according to the public trustee, would be allowed to ask the court. So anybody's allowed to ask the court for someone to manage the estate of a deceased person. What are you talking about? Anybody can do that. Any can instead ask the public trustee to manage it. See? The public trustee will do so unless they have a good reason not to. Isn't that interesting? Isn't that interesting? Oh man, this is lovely. This is 7 right here, administration of estates. On the public trustee undertaking by declaration in writing, signed by him and deposited in the Supreme Court registry, to administer the estate, he shall have the same powers as if he had been appointed by the last will of the deceased person or by the executor. So it could be done this way right here. Somebody can ask him, you know, apply to them, you know, reach out to them and say, hey, you know, can you manage this estate? Or it could be done like this. He can go, the public trustee can go and make a declaration in writing and signed by him and say, hey man, Supreme Court, check this out, I need to administer this estate, and if he gets that granted, he'll have the same powers as if he had been appointed by a will, right? Okay, that's interesting. 3, there's another way here. For the purpose of the administration, the public trustee may exercise those administrative powers and authorities of the Supreme Court, which may be conferred upon him by the rules, subject to the condition imposed by the rules. So let's get a simpler version, right? Because when I first read that, I didn't know what the hell they were talking about. I understand it now, and so that's why I want to show you that there's a simpler way to look at it. So it says here, to manage the estate, the public trustee can use the administrative powers of the Supreme Court. What type of powers? Administrative powers of the Supreme Court that are given to him by the rules, as long as he follows any conditions set by those rules. And what are the rules? He has to follow the rules of what? The rules of the Act. That's what the rules mean right here, right? Rules of the Act. It says here, rules shall be made. Shit, what's going on here? Rules shall be made under this Act for enabling the public trustee to take the opinion of the court. See, the court has an opinion now, okay, on any question arising in the course of any administration without judicial proceedings, and otherwise for making the procedure under this section simple and inexpensive. Okay, this is talking more about the intent. I think this is, how about this? This is like the intention. It says here, the rules shall be made. The rules will be created under this law to allow public trustee to ask the court for its opinion on any issue that come up during administration without having to go through a full court process. These rules will also make the process easier and cheaper. So okay, can we look at this and say that anyway, hold on. Maybe it'll continue. Hold on. It says here, where an application is made to the court for a grant of probate or letters of administration in the estate of any deceased person, or proceedings have been instituted in the court for the administration of the estate, and by reason of the small value of the estate, it appears to the court that the estate can be more economically administered by the public trustee than by any other person, or that for any other reason it is expedient that the estate should be administered by him instead of by any other person, the court may order that the estate shall be administered by him, and thereupon subject to any directions by the court. This section shall apply as if the administration of the estate had been undertaken by him in pursuance of this section. Okay, so let's break it down. All right, bam, there you go. Here's a simpler version. If someone applies to the court for probate of or letters of administration of a deceased person, right, it's a state, or if there are proceedings to manage the estate, and the court thinks the estate can be managed more cheaply by the public trustee due to its small value, or for any other reason, the court can decide that the public trustee shall manage the estate. Once the court orders this, the estate shall be handed by the public trustee as if they had taken it on according to this law, following any court instructions. That is interesting. Sounds fair. Granting probate to public trustees. It says where, in pursuance of the rules, public trustees are authorized to accept by that name probates of wills or letters of administration the court may grant such probates or letters to the public trustee by that name, and for that purpose the court shall consider the public trustee as in law entitled equally with any other person or class of persons to obtain the grant of letters of administration, except that the consent or citation of the public trustee shall not be required for the grant of letters of administration to any other person, and that, as between the public trustees and the widow or next of kin of the deceased, the widow or next of kin shall be deferred, unless for good cause shown the contrary. So, that's a lot of anyway, that's a lot, right? But it's basically just saying, it's talking about mainly these individuals right here, widows or next of kin or widower, and we can plug it in again, use chat, and here you go. It says, if the rules allows the public trustee to accept probates of wills or letters of administration, the court can grant them to the public trustee under that name. The court will treat the public trustee as having the same rights as any other person to receive these grants. However, the public trustee the public trustee's consent isn't needed to grant letters of administration to someone else. Oh, okay. Also, if there is a choice between the public trustee and the deceased spouse or closest family member, the spouse or family member will be preferred, unless there's good reason not to. Hey, see? Much better. Isn't that interesting? Here we are on number 2. Any executor who has obtained probate, or any administrator who has obtained letters of administration, and notwithstanding he has acted in the administration of the deceased estates, may, with the sanction of the court, and after such notice to the persons beneficially interested, as the court may direct, transfer such estate to the public trustee for administration, either solely or jointly with the continuing executors or administrators, if any. Well, let's check it out one by one. Here's a simpler version. An executor who has received probate, or an administrator who has received letters of administration and who has been managing the deceased estate, can, with the court's approval and after notifying the interested parties, as the court directs, transfer the estate of the public trustee for management. This can be done either alone or together with any other executor or administrators still involved. Here we go. The order of the court sanctioning such transfer shall, subject to this act, give the public trustee all powers of such executor and administrator, and such executor and administrator shall not be in any way liable in respect of any act or default in reference to such estate subsequent to the date of such order, other than the act or default of himself or of persons other than himself, or for whose conduct he is in law responsible. Wow, okay. Well, this simply means this. Once the court approves a transfer, the public trustee will have all the powers of the executor or administrator. After that order, the executor or administrator won't be responsible for any actions or mistakes related to the estate, except for their own actions or those of people they are legally responsible for. Okay? You ask yourself, why didn't they just say that? Right? Why didn't they just say it simply? No, they gotta make it all freaking legalese. Custodian trustee, subject to the rules, the public trustee may, if he consents to the act as such, and whether or not the number of trustees has been reduced below the original number, be appointed to be custodian trustee of any trust. Okay, by order of the court made on the application of any person on whose application to the court may order the appointment of a new trustee. Okay. Or by a testator, settlor, or any creator of any trust. Or by the person having power to appoint new trustees. So this is interesting. This is interesting because this is very interesting. You guys should see what I've recorded two different trust deeds, and one of them I appointed the Minister of Finance as trustee. So it was very interesting. Okay. So and it's just how about we just do that? He knows what's up. Okay. The public trustee can be appointed as the custodian trustee of any trust, as long as they agree to take on the role. Agreement. Like you could send them a letter and say, hey man, this is my intention is to appoint you as public trustee of blah blah blah. And if you don't, return what I'm sending you, this thing of value that I'm appointing you trustee. If you don't return it, then it's going to be interpreted as an agreement that we have. So please, take 30 days and respond to me and accordingly if you're going to take on this position or not. If you don't respond to me, I'm going to assume that you're accepting the role, and that conduct would be interpreted as consent. So that's agreement. See, as they agree, so we're going to read again. As long as they agree to take on the role. This can happen even if the number of trustees has gone below the original amount. The public trustees can be appointed by the court order if someone asks the court to appoint a new trustee, or by a person who created the trust, or a settlor, by the person who has the authority to appoint new trustees. I'm laughing because, man, I'm telling you, man, I gotta show you something, man, but I'll do that some other video. This is very interesting. I like it. So, 2. Where the public trustee is appointed to be a custodian trustee of any trust, the trust property shall be transferred to the custodian trustee as if he were a sole trustee, and for that purpose vesting orders may, where necessary, be made under any act relating to trusts. The management of a trust property and the exercise of any power or discretion exercisable by the trustee under the trust shall remain vested in the trustees other than the custodian trustee, which trustees are in this act referred to as managing trustees. Okay. Hold on, let's do this. I'll bring it here. What's this? What? Huh? Same thing. Oh, because okay, got it. I see what happened. Hold on. And that didn't work out. Well, god damn it. And I also had this. There you go. So, even though the public trustee is the custodian trustee, the management of the trust property and any decisions that the trustee can make will stay with the other trustees, called managing trustees, between the custodian trustee and the managing trustees, and without affecting the rights of anyone else. The custodian trustee will. It looks like the sentence cuts off there if you want me. Oh, this is really good. Yeah, here you go. Pretty good. Okay, the public trustee will hold onto all securities. Wow, and documents related to trust property. However, the managing trustee will have free access to these documents and can make copies. So see, a public trustee as custodian trustee will hold on to all securities and documents related. Wow, okay. That's wild. Make copies of the actual. Okay, the custodian trustee must agree to and help with any actions needed for the managing trustees to do their job or use any powers given to them. This includes things like depositing money or depositing securities in court. Wow. However, the custodian trustee doesn't have to agree if doing so would be a breach of trust, or if it would make them personally liable for something like calls or other obligations. Calls. I wonder if that's margin calls it's talking about. As long as the custodian trustee doesn't agree to something, they won't be responsible for any actions or mistakes made by the managing trustees. Oh, okay, that's fair. It's fair. All sums payable to or out of the income of or capital of the trust property shall be paid to or by the custodian trustee. Yup. Damn. You see the thing, man, I gotta say, I wonder if I have that, man. Let me see. I want to show you guys. Let me see. Where is it? Pertain to hold on. Where is it? Man, I know I have it. I don't know where it is. Sheesh. Oh man, I can't show you guys right now. I have to show you another video that I have in PDF, but I think I moved some stuff around. I don't remember where it is. But anyway, provided that the custodian trustee may allow the dividends and other income derived from the trust property to be paid to the managing trustees or to such persons as they direct, or into such bank to the credit of such person, to the credit of such person as they may direct, and in such case shall be exonerated from seeing the application. Well, shucks. Okay, so here we go. We're gonna have to do all of this. We're gonna have to simplify all of this. Okay. Anything else? Yes. Okay, good. Let's simplify all this. Okay, right here. It says the custodian. So why I'm saying this, look, when I conveyed title with interest to the public trustee, I appointed one of them as custodian trustee, and I appointed the other one as managing trustee. And I did that when I first read this act. That's the reason I did that, because that's how I understood it to be. So when I'm reading it right now, and it's just, it just reaffirms. I'm happy that I was able to interpret it in that time in a way that I'm looking at now, that I still agreed with that interpretation, how I did it. So it was a little bit, because, when you're just learning, you're hoping you don't make mistakes, or hoping that you learn is sufficient. But yeah, it says here. Here's a simpler version of the entire text. The custodian trustee can allow any income, like dividends, from the trust property to be paid to the managing trustees, someone they direct, or a bank account which they specify. In this case, the custodian trustee is not responsible for how the money is used or any loss of or misuse of it. When it comes to appointing new trustees, the managing trustees alone will have the power to do so. However, the custodian trustee can still ask the court to appoint a new trustee just like any other trustee. For the purpose of any law related to trustees, the custodian trustee will not be counted as one of the trustees when determining the number of trustees. Okay, if the custodian trustees acts in good faith, they won't be held responsible for accepting and acting on any written statements from the managing trustee about things like birth, death, marriages, or other facts that might affect the trust property. They also won't be liable for acting on legal advice that the managing trustee got on their own without involving the custodian trustee. If either the custodian trustee, a managing trustee, or a beneficiary asks the court to end the custodian trusteeship, the court is satisfied that it's the beneficiary's wish or that it makes sense to do so, the court can make an order to end the custodianship trusteeship. The court can also make necessary orders or give directions based on the situation. That's interesting to know. That's interesting. It makes a lot of sense. What's happening, man? Okay. We are halfway there. We are on page 11 of 22. I'm just gonna read, I guess, this one. I'm just gonna read number 10 and I'll call it a night. It's late right now, but I'm gonna read the rest tomorrow. But we're here in number 10. The public trustee may, by that name or any other sufficient description, be appointed to be trustee of any will or settlement. Look at that, or settlement. Or settlement. That is wild, baby. You know, this just confirms that these public trustees, like for example, right? I'll give you an example. Let's say you get a ticket, right? Some stuff, I don't know, no insurance or driving, whatever it is, right? The ticket is a charge, is a bill. And if you accept the bill and you provide a promissory note, let's say, and you assign that promissory note to a public trustee, like let's say the public officer of the Department of Transport, right? The main manager, supervisor, I don't know, whatever you want to call him, the king of the transport division. How about that, right? Assign a promissory note as collateral security for the obligation that is due on the ticket. That would make sense because we're appointing them public trustee, or, and for settlement. That's what we do. We're creditors. We have unlimited credit. They want credit, I got you. Right? We settle things as creditors. So anyway, so that's why when I see this word settlement here, it automatically jumps out to me. So let's do it. Let's say it again. The public trustee may, by that name, look. Let's bring it here. Watch. Let's bring it into chat and let's make it simpler. But I want to read it first because we gotta read it like this and then make sense of it. The public trustee may, by that name or any other sufficient description, be appointed to be trustee of any will or settlement or other instrument creating a trust, or to perform any trust or duty belonging to a class which he is authorized by rules to accept, and may be so appointed whether the will or settlement or instrument creating the trust or duty was made or came into operation before or after the passing of this act, and either as an original or as a new trustee or as an additional trustee in the same class and in the same manner and by the same person or court as if he were a private trustee. With this addition, that although the trustee originally appointed were two or more, the public trustee may be appointed sole trustee. A whole lot of stuff, right? Well, here's a simpler version. The public trustee can be appointed as the trustee of any will, settlement, or other document that creates a trust. Amazing. Or to perform any trust or duty that the rules allow them to accept. They can be appointed whether the document was made before or after this law was passed. The public trustee can be appointed either as an original trustee, he can be appointed as a new trustee, or an additional trustee, just like a private trustee. Additionally, if there were originally two or more trustees, the public trustee can be appointed as a sole trustee. Interesting. I like this one. This just substantiates it. Yeah, I mean, it's just, man, awesome stuff. This is awesome. So, where the public trustee has been appointed as a trustee of any trust, a co-trustee may retire from the trust under and in accordance with the provisions of any act relating to trustees, notwithstanding that there are not more than two trustees, and without such consents as are required by such provisions. Let's plug it in. Let's see what it says, what it means in the simpler version. If there is a simpler version, that's simpler. Here's a simpler version. If the public trustee has been appointed as a trustee of a trust, a co-trustee can retire from the trust according to the rules and in any law about trustees. This can happen even if there were only two trustees, and it doesn't require the usual consents that would normally be needed under those laws. The public trustee shall not be so appointed either as a new or additional trustee where the will, where the settlement, or the other instrument creating the trust or any duty contains a direction to the contrary, unless the court otherwise orders it. Well, the public trustee shall not be appointed either as a new trustee or additional trustee, blah, creating trust as directed to the contrary. Okay, so is this like, well, let's see. The public trustee cannot be appointed as a new or additional trustee as if the will or settlement or other document creating the trust says otherwise, unless the court decides differently. Okay. Notice of any proposed appointment of the public trustee, either as a new or additional trustee, shall where practicable be given in the prescribed manner to all persons beneficially interested who are residing or resident in Belize and whose addresses are known to the person proposing to make the appointment, or if such beneficiaries are infants, to their guardians. Okay. Where any person to whom such notice has been given within 21 days from the receipt of the notice applies to the court may, if having regard to the interest of all beneficiaries it considers it expedient to do so, make an order prohibiting the appointment being made. Oh, okay, you can say, well, I don't want that because I don't need an appointment to be made because I have evidence that this goes contrary to the interest of the beneficiaries. Okay. It says here, a failure to give any such notice shall not invalidate any appointment made under this section. Okay. Anyway, we are here on number 12, which is, page 12, but section 11. We're going to call it a night. I'm going to call it a night. And this is part 1 of public trustee. Let's go up here. Where is it? Public Trustee Act, Chapter 199. Alright, guys. Peace and love. Call it a night.